and welcome back. I'm Christina Jump. I am the Civil Litigation Department Head for the Constitutional Law Center for Muslims in America, and I'm here today to talk to you about freedom of speech. And as you can tell, I am still sheltering at home, so welcome back to my home. And I apologize if there are any random sounds in the background. I've tried to control those, but you never know. It seems that the dog has a freedom of speech as well. So I'll try to keep that under control. All right, so we're going to talk today a little bit for an introduction into protected speech, or what is illegal hate speech. How much is really protected by the First Amendment of the Constitution versus where do you draw the line where things actually become illegal and against the law. So you may recognize from these images that are coming up on the screen from the prior football season, where taking a knee was something that was seen, I think, in just about every game, beginning with Colin Kaepernick and continuing on for all of the teams that you see there. Now, the statement that popped up is actually from Major League Soccer, which issued a statement, but regarding the same thing. And Major League Soccer had in its statement to say that all players have every right to exercise their constitutional rights, and we will do everything in our power to defend those rights. So for the individuals to go ahead and take a knee. Now, for National Football League, obviously there was much more discussion. Some were offended by the choice of expression of taking a knee during the national anthem. Others were offended by the fact that some owners tried to limit it or tried to put restrictions on it or punishments as a result. And, it's a pretty heated, pretty emotional issue. Some equated it to flag burning. So that's something that came about. I think the way that most scholars and most constitutional lawyers came down on it is it's absolutely their right to do that. And it is also absolutely an employer's right to establish rules as long as they're consistently applied, and it is the public's right to react to those rules. So that's what we saw play out in that regard. And one of our former Supreme Court justices made this statement, which is on the screen now, that debate on public issues should be uninhibited, robust, and wide open, and that may include vehement, caustic, and sometimes unpleasantly sharp attacks on government and on public officials. That's exactly what it's supposed to be. Even if it's unpleasant, it is supposed to be free speech. It's supposed to be freely uninhibited. So what speech is not protected? Where is that line? Well, obscenity, in particular child pornography, is not protected. Fighting words, those meant to incite violence, are not protected. Defamation, in other words, something that is provably wrong, not just makes you look bad, not an I think or I feel matter of opinion, but saying that somebody did something they did not do, or was a member of a group they're never a member of. That includes libel, which is the written, including the internet version, and slander, which is spoken, as well as perjury. You cannot lie under oath. That is not protected under any circumstances ever. Blackmail, can't force somebody to do something that's not considered free speech. That is against the law. And incitement to imminent lawless action, meaning that you have identified a time, a place, a person, and it's not hypothetical, where there could be lawless action or physical harm. True threats of violence are not protected. Now, in a public forum, there is a lot more right to freedom of speech, and far, far fewer restrictions are permitted. So let's discuss what a public forum actually is. A public forum is a place that by tradition or practice has been held out for general use by the public for speech-related purposes. This is often a public park, sidewalks, streets, where people are free to express something. It's not restricted for any other purpose necessarily. And I don't mean certainly cars drive on streets, that is another purpose, but it's not, for example, a government building that is used for governmental purposes on a regular basis. There cannot, in a true public forum, a true park, outside sidewalks, streets, whatever, there cannot be content regulation. You cannot regulate, it's not lawful for a municipality or state or city to regulate the content of what is expressed. There are, however, permissible restrictions on the time of expression, the place of expression specifically, or the manner in which it occurs, as long as those are all consistently applied. Now that contrasts with a limited designated public forum, and this is public property in most circumstances that is, while not typically dedicated to public assembly, it has been open to expressive activity in the past. That can include university meeting rooms that are open for use by student organizations. It can include a city auditorium that's open for theater performances. And with this, the government has more broad latitude for restrictions that further the public's interest and preserve order. The restrictions must still be reasonable, and they cannot be based on the particular viewpoint. So a government cannot limit what is said, even in these limited public forums, these not quite so open public forums. They cannot restrict what is said based simply on the point of view of the speaker. That cannot be done. You can't say, well, we're not going to have anybody here who speaks on behalf of all Republicans, on behalf of all Democrats, in favor of a specific political issue or against a specific political issue. Limiting it that way is against the Constitution. That is unconstitutional and against the First Amendment. In a non-public forum, however, that is in a private setting, that is on privately owned property or publicly owned property that is devoted almost exclusively to a different purpose, such as airports, jailhouses, military bases, private residential properties, and then this would also include, for the most part, private clubs. Government may impose speech restrictions as long as they are reasonably related to the forum's main function, and as long as they include the restrictions, they can discriminate actually in these settings. And so in this privately owned property setting or publicly owned property that is dedicated almost exclusively to a different purpose, there can be restrictions that do discriminate against particular viewpoints. It is okay to limit it in those situations because those are not so much public places, or at least not so much public places that are intended for the purpose of expressing viewpoints. There is, however, even in those private places or those restricted public places, no right to an audience. That is not guaranteed by the First Amendment. Nobody has to listen. Now, here's an example of something that is about as close to the border of what's accepted versus prohibited as has come up in public. This is a quote from Irving Rubin of the Jewish Defense League at a press conference. And this was many years ago, but I think it's an apt quote still. And he stated, "We are offering $500 that I have in my hand right here to any member of the community, be he Gentile or Jewish, who kills or maims or seriously injures a member of the American Nazi Party." This offer is being made on the East Coast, on the West Coast. And if they bring us the ears, we'll make it $1,000. The fact of the matter is, we're deadly serious. This is not said in jest, lest there be any doubt. We are deadly serious. Now, is that a true threat? Well, if you look at that, what it really turns out to be is that he's saying it could happen anywhere, East Coast, West Coast, any member of the Nazi Party, not a specific one, not identifying a particular individual. So while it is distasteful, while it is violent, while it is absolutely inflammatory rhetoric, it is not necessarily unconstitutional because it is not really specific enough. It brings it really close by saying this is not said in jest and we are deadly serious and I got the money right here. But he's not saying go do it right now, go after this particular individual right now. Here's where he is, here's where he lives. As soon as I put the microphone down, let's go. Since it's not said in that context, you know, it is walking up to that line, but I don't believe it's over it. Okay, we also want to look at hate crimes. A lot of times there are statutes that do specify exactly what a hate crime is, which further limits free speech, but it is consistent with the Constitution, with the First Amendment of the Constitution, to limit in that way. For example, there's a Wisconsin statute that reads, a criminal sentence may be increased if a person intentionally selected the victim based on the victim's race, religion, disability, sexual orientation, national origin, or ancestry, basing it on those characteristics, targeting the victim for those reasons makes it a hate crime and increases the punishment. So I mentioned earlier that some equated flag burning to the concept of taking a knee. And so
why you believe that people who burn the flag in America should be allowed to do so, and yet you personally, if you had the chance, would sling them all in jail?
Yeah, if I were king, I would not allow people to go about burning the American flag. However, we have a First Amendment which says that the right of free speech shall not be abridged, and it is addressed in particular to speech critical of the government. I mean, that was the main kind of speech that tyrants would seek to suppress. Burning the flag is a form of expression. Speech doesn't just mean written words or oral words. It could be semaphore. Burning a flag is a symbol that expresses an idea. I hate the government is unjust, whatever.
So right there we have former Supreme Court Justice Antonin Scalia expressing why, even though he hates the idea that flag burning is absolutely protected, he doesn't agree with it, he doesn't like it, he doesn't want to see it happen, and he absolutely would stand up for the right to do it because it is protected free speech under the Constitution. So now I want to take you to a different point of view on the same subject, and you may recognize the quote and the speaker here in just a minute as we pull this up.
Developing this afternoon, President-elect Donald Trump wants to jail people who would burn an American flag or revoke their citizenship. On Twitter, he wrote, "Nobody should be allowed to burn the American flag, and there must be consequences." Channel 2's George Colley live in Washington, D.C. with reaction on this. George.
Well, good evening. Yes, the president-elect's tweet indicates that he may support prosecuting those that burn the flag, but the Constitution says otherwise.
Exactly.
A First Amendment battle could be brewing in the nation's capital. A tweet by President-elect Donald Trump is resurrecting the debate over flag burning. Early Tuesday morning, Trump wrote, "Nobody should be allowed to burn the American flag. If they do, there must be consequences, perhaps loss of citizenship or a year in jail." His communications director further said the president-elect is a, quote, very strong supporter of the First Amendment, but
burning the American flag, which has absolutely no place in our society.
As for the potential consequences the president-elect mentioned, under the law, no U.S. citizen can have their citizenship revoked against their will. They can only renounce it themselves.
I do not approve of burning the flag. I think there should be some punishment, but right now, the Supreme Court decision is that people are free to express themselves.
The Supreme Court twice reaffirmed the First Amendment free speech protections allowing flag burning. The late Justice Antonin Scalia, a strict constitutionalist, explains his views in this 2012 interview.
Okay, and so then it goes back into the example that we just heard earlier from Justice Scalia. So you've got two very different viewpoints there. Can you punish someone, put them in jail, possibly even strip their citizenship because they took an act that voiced disagreement with the government? No, you cannot. And even the Supreme Court justice who hates it, and you had there the late Senator John McCain saying he hates it, but it's free speech, and that's all permitted. That's all acceptable. It's what people are within their rights to do, and it's quite frankly exactly how this country and why this country was created, so that people would be able to speak out against the government that they have if they disagree. Now, this has also led or come up in the context, particularly as it affects much of our client base and the members of the community, with protests that have happened at mosques or about mosques. So let's look into what that involves. One statute that is triggered by these is the FACE Act, which is Freedom of Access to Clinic Entrances Act. And this was the main purpose of this, the main motivation for this, was actually triggered by protecting access to abortion clinics and other types of medical clinics that might have had protesters outside them, Planned Parenthood, those types of things. However, the language is applicable to religious worship and places of religious worship. So the FACE Act, or Freedom of Access to Clinic Entrances Act, makes it illegal for there to be a use of physical force, threat of physical force, or physical obstruction to intentionally injure, intimidate, interfere with, or attempt to injure, intimidate, or interfere with any person who is exercising or trying to exercise their First Amendment right of religious freedom at a place of religious worship. So this protects locations such as mosques such as any place of worship at all. It protects other gathering spaces. It can also protect a community center from protests. It does not mean the protests cannot happen. They can, but there are restrictions on the time, manner, and place. So things that are prohibited would be blocking anybody's access to the entrance of the facility, impairing cars from entering or exiting the facility, physically stopping people as they're trying to walk toward the entrance or through a parking lot, making it difficult or dangerous for anybody to get in or out, trespassing on the property of the facility, committing an act of violence on a clinic employee, which again would apply to a place of worship, escort or patient or worshiper, any vandalism or threats of violence or stalking an employee or a person going there to worship, arson or threats of arson, bombings or threats of bombs. All of those are absolutely prohibited by the FACE Act. What is allowed is distributing literature, carrying signs, shouting, as long as it doesn't contain threats, singing hymns, and signs like these. Now, several years ago, the Westboro Baptist Church certainly had a lot of protests, had a lot to say. But if you look at these pictures, this woman in the picture in the purple sweater is standing on a public sidewalk, holding a lot of signs, had a lot of people disagreeing with her, many of whom were standing around or nearby. Absolutely entitled to do that. She's holding 4 signs all on her own. Doesn't look like she's got a lot of people with her there in that particular clip or in that particular moment. But there are, as you can see, other protests that happened there as well, where others were holding similar signs, expressing similar thoughts, and that's permissible, as long as they're not yelling threats, as long as they're not preventing others from having access. That is permissible. So are counter protests. Counter protests are permissible as well. And a lot of times, if somebody knows, if an organization or an entity knows that there is going to be a particular demonstration, maybe it's been announced on Facebook, on the news, somehow on social media, or on Instagram, then there may be a time to contact the local law enforcement in advance, and they will set up areas they will know to be prepared to be there to make sure that it's peaceful demonstration, that those who are demonstrating against the particular location are in one spot, and then the counter protesters are in another spot. Now, this cartoon pretty much wraps it up. I'm all for free speech, unless I find it personally offensive. And that's the thing about the First Amendment. That's the thing about free speech. That's exactly what Justice Scalia and Senator McCain were saying in those clips, which we played earlier, is that you can't just be in favor of the First Amendment and free speech when it coincides with your viewpoints. Being in favor of free speech, being in favor of the First Amendment, supporting the Constitution means being in favor of it even when you hate content. And here is a frequently quoted statement. I disapprove of what you have to say. I disapprove of what you say, but I will defend to the death your right to say it. Widely attributed to Voltaire. He didn't say it. So as long as we're talking about freedom of speech, let's accurately attribute that. This was actually a statement that was made by this woman here. She said it. I disapprove of what you say, but I will defend to the death your right to say it. Stated by Evelyn Beatrice Hall in Friends of Voltaire from 1906. She wrote under a pseudonym at the time, and it's widely associated with Voltaire because she wrote it in the Friends of Voltaire publication, but she said it, not him. All right, well, I want to say thank you very much. I appreciate you being here. I appreciate you coming in to listen. Stay safe, everybody. And again, if anyone has further questions or would like more information, you're welcome to contact us on our website. That's CLCMA.org, Constitutional Law Center for Muslims in America, CLCMA.org. My name again is Christina Jump, and I am the Civil Litigation Department Head for the Constitutional Law Center. Thanks very much for tuning in. Everybody stay safe and feel free to keep expressing yourselves. Thank you.